I am Michael Fallings, the managing partner here in Austin, Texas. I focus my practice on labor and employment matters in the federal government, but also in the state of Texas. I work on EEOC matters and whistleblower retaliation matters, and we'll be discussing whistleblower matters today. As you can see on your screen, here's a little bit of the bio that's on our firm's website, a little bit about myself and my history of practicing law. I'll let Nathan introduce himself here now.
Thanks, Mike. As Mr. Fallings discussed, my name is Nathan Simmons. I recently joined Tully Rinckey last year, but have been working prior to that. And even before then, I've really dedicated my life to workers' rights law for the most part. Even prior to going to law school, I helped organize a hiring hall union here in Austin. But I've spent the entirety of my life here in the States. I grew up in Dallas, went to school in Austin, and recently spent some time in Houston as well for work. Very much like Mike, I'm also working in federal employment as well as also private employment, representing workers in employment and labor disputes.
Okay, thank you, Nathan. Per the topic of today, we're talking about Texas whistleblower laws and the burden of proof on Texas whistleblower matters. And the topics for today's webinar specifically will be about how Texas whistleblower laws apply, the definition of a whistleblower, what damages you could obtain in Texas whistleblower cases, how to exercise your whistleblower rights, again, the burden of proof for a Texas whistleblower, and any recent Texas whistleblower decisions. We'll go over those. And just a disclaimer, again, this is specifically for Texas state matters, not for other states, and not specifically for the federal government. This is for Texas matters. Another disclaimer is this is not meant to replace any specific legal advice for any specific facts of a legal matter that may be going on. This is guidance for individuals, general guidance, but not specific guidance for a specific case. But with those two disclaimers out of the way, we'll move forward for the next slide here. How Texas whistleblowers apply. So the Texas Whistleblower Act, which is Section 554 of the Texas Government Code, is the law that authorizes whistleblower protection. Specifically, it prohibits retaliation against public employees by state and local government entities on the employee for reporting a violation of law committed by the employing governmental entity. So, as you can see, it applies to public employees. These are employees that work for state or local entities, different from employees that are working for private entities. It's different from federal whistleblower laws, which allow for protection of private employees as well. There's a good faith requirement under the Texas whistleblower law, which it applies when the employee reports that they believe there's a violation of law in good faith. So that means that the employee has to have a genuine belief or a good faith that there is a violation of law. Even if there isn't a violation of law, as long as the employee has a good faith belief, then the law could apply. And specifically, the employee must genuinely and reasonably believe the action is being reported is a violation of law, even if it's not, for it to apply. So the purpose is to just foster accountability of public institutions to promote transparency. But again, we're specifically talking about here when an employee is reporting something they genuinely believe is in violation of a law, even if it's not. If they suffer retaliation as a result, they could have protection, meaning that they report that there's a violation of a practice that they think the business is undergoing, and it's not even actually occurring, but they are terminated as a result or demoted as a result because they complained, because they reported it to a management official, that could still have protection. So it's important to understand that as a Texas whistleblower. We could go on to the next slide. And then just the overall definition of a whistleblower. A whistleblower is an employee who exposes or reports fraudulent activity within an organization to the proper authority. So there's a lot of parts of that. An employee, like we just mentioned earlier, an employee for Texas purposes is a public employee, meaning an employee or appointed officer who is paid to perform services for a state or local government entity. So again, this is Texas whistleblower laws apply to public employees. The employee must act in good faith in making their report. That harkens back to what I was discussing earlier, must have a good faith belief in that a violation is occurring. The report must be a violation of law by a state or local government entity or by another public employee. And we have some definitions of what a local entity and a state entity would mean, but you must be reporting something that would be violation of a law or fraudulent activity. And report means basically you're informing a management official or an organization, preferably in writing, so there's proof of you doing that. You're reporting the violation to the appropriate authority, whether it's even human resources. You're making somebody aware of what the violation is. And then if you're subject to an adverse action by the governmental entity, that could be retaliation. So for example, if you're subject to a demotion, a termination, even a lowered performance evaluation, some action that affects the terms and conditions of your employment, even a transfer or a different working assignment could qualify. These are actions that occur after you've made your report, and those actions are taken by the people that know about your reports of whistleblower activity. So that's the definition here, how we're describing it as a whistleblower. We can go to the next slide. So as far as damages for a whistleblower case, so it's important to understand that there are different statutory caps for monetary damages here. And as you can see on the screen, we have here as far as how the caps apply for each number of employees. It's also important to understand the types of damages that could be claimed for whistleblowers. Injunctive relief, which basically means you want the action to stop. Actual damages that you could directly relate to your retaliation. If you were terminated, such as back pay, you've lost wages, or medical damages. Court costs and attorney's fees if you've hired an attorney because of the whistleblower retaliation. You may have had attorney's fees that you would like reimbursed, or court costs that you have to pay for a court reporter, things like that. You could have those types of things reimbursed. A suspended employee or terminated employee could seek reinstatement. Like I said, compensation for lost wages and benefits because of the whistleblower retaliation that has occurred. And as far as the caps on monetary damages, we have him listed here. And I was going to turn it over to Nathan to speak more about this and to go on for the other slides as well.
So just to sort of touch a little bit on the statutory caps, the statutory caps themselves are applicable to compensatory damages. Now, compensatory damages aren't aren't all that is you can get for a case like this. But the compensatory damages can include things like emotional distress, as well as also issues regarding like lost benefits, lost pay, things that would otherwise make you whole, or otherwise you can seek out regarding uh, regarding the pain and suffering you've gone through. Now, as you can tell, the amount of statutory caps for compensatory damages, those are determined by the size of the entity for which you are filing the whistleblowing report against. So if the entity has less than 101 employees within a 20 or more calendar weeks in the year that you either filed the suit or the year before you filed the suit, then the highest amount you can get for compensatory damages is $50,000. And then if it's between 100 to 201 employees, that goes up to 100,000 for the compensatory cap. And then for 200,000, that would be applied when there's between 200 and 501 employees. And then 250,000, which is the highest that compensatory caps can go. That would be if you are reporting against an entity that has over 500 employees. Now, that being said, just because there's a cap on compensatory damages doesn't mean that there aren't other monetary damages that you can request. So, for example, you can ask for exemplary damages, which essentially are almost punitive damages. Basically, you ask that, hey, because the agency or governmental entity acted with such clear malice, that they should also be punished and made an example of. And that, I believe, does not face the same caps as compensatory damages. Next slide, please. So in order to exercise your whistleblower rights, first you have to meet the definition of a whistleblower. So again, if you are a public employee, this would apply to you. If you're a private employee, unfortunately, you are excluded from this. If you are would like to exercise your whistleblower rights, what you would have to do is report a violation within 90 days from when that violation either occurred or when you discovered that the violation had happened. So, for example, let's say that an agency had been allowing for some level of fraud to occur for over 2 years. Well, if you discover it 2 years after the fact, then you still have 90 days from which you can report that violation. Also, the whistleblower must report to the appropriate law enforcement authority. The authority tends to be a part of either the state or local governmental entity, but could be a part of the federal government that the employee in good faith is authorized to deal with. The whistleblower must reasonably be believed, or the reporting entity that the whistleblower reports to must reasonably be believed to be authorized to regulate under or enforce the law allegedly violated in whistleblower's report. So, for example, let's say you have an anti-harassment claim. It would be best to report it to like human resources most of the time, or there may be an anti-harassment unit to report to. Same with if you find employment discrimination on the basis of sex or something like that, then you'd be trying to report to the EEO counselor for that agency. You also must the law enforcement authority must also reasonably be believed to be authorized to investigate or prosecute a violation of criminal law. So even if you just report it to a coworker, like who's your best friend or something like that, unfortunately, that doesn't count as a law enforcement authority unless they are themselves part of the law enforcement authority. Sovereign immunity for state and local entities, that is waived for violations of the TWA. So that's a part of the reason why a whistleblower can bring a suit against these entities without worrying about sovereign immunity. Sovereign immunity, specifically in this case, it refers to essentially how state and local governmental entities have to agree essentially to be sued. And in this case, if you're trying to report a violation by that state or local entity, it is essentially presumed that, well, of course, they're going to want to waive sovereign immunity, or at the very least, we're not going to let them try to make a choice in whether or not they waive sovereign immunity. A whistleblower must initiate action under the grievance or appeal procedures of the employing entity relating to the suspension, termination, or adverse personnel action that is being taken against the whistleblower for their reporting. The time spent going through the grievance/appeal procedures does not count against the 90-day deadline for you to report. And you also do not have to exhaust administratively this grievance or appeal procedures before filing a whistleblower suit. Next slide, please. As for burden of proof, under the TWA, the public employee filing the whistleblower claim has the burden of proof. What that means is that they have to prove that the action taken against them was because they reported a violation of law. Now, there is an exception. The exception is when, let's say, someone that has already filed a whistleblower report of some form, that the action taken against them happens within 90 days. Then it's essentially presumed that that action was in retaliation to the whistleblower report. It's essentially a temporal proximity in this case, in which case then the burden of proof has been satisfied for the public employee filing the whistleblower claim. There is an affirmative defense against claims of whistleblower against whistleblower claims, in particular for a governmental entity, if they are able to prove that they would have taken the adverse action against this employee, regardless of whether or not they filed a Whistleblower Act, then that could be an affirmative defense to the whistleblower claim and potentially defeat that whistleblower claim, essentially. Next slide, please. So because the Texas Whistleblower Act is a state law, that means that what we're going to mostly be focusing on are cases that happen in state courts. So generally a case that happens at the Supreme Court or, like, let's say a federal district court, that's not going to be as pertinent in the enforcement of a Texas Whistleblower Act case when compared to something that happens in the state court or the Texas Supreme Court. So recent decisions that have been made in the past year that are of interest, there's the Texas Health and Human Services Commission v. Pope that happened at the Supreme Court of Texas. This one, the court ruled that reporting the actions of a private employee is not protected activity under TWA. So even if what the actions that a private employee are doing are reprehensible, unfortunately, that's not really covered by the TWA. There are other statutes that can be used against this violating private employee, but TWA does not provide an actionable claim. The second case is the City of Houston v. Garcia, which happened in Houston, as mentioned in the case name there. In this one in particular, this one ruled that if an agency does not have a grievance or appeal process, then the reporting employee must still craft an informal grievance that suffices the given reasonable notice to the employing governmental entity to at least let them know that, hey, I'm reporting that this is a violation, even if you have not given me procedures to carry about a grievance or appeal. the good thing about that is that, most of the time, so long as you're making a good faith effort and you're initiating, then that means that the employee cannot be faulted for failing to file a quote unquote grievance with a designated office if that office does not have the authority to enforce the law. Which, obviously, makes sense. Ultimately, it's not the employee's fault that the entity has failed to set up any sort of procedure that with any sort of bite regarding any violations occurring at the entity itself. Therefore, it would not make any sense to punish the employee for the entity's oversight. And then finally, the final case that's been ruled on that I want to bring up in the past year is City of Fort Worth v. Burke, which actually the court that this was ruled in is in Dallas. So a little counterintuitive compared to the previous case we talked about here. But in that case, the court ruled that the whistleblower must initiate the grievance or appeal process, but so long as they put in the good faith effort to exhaust the process, they do not have to actually exhaust the process. So long as you initiate it and attempt to go through the process, at the very least, you can still file a whistleblower claim. And all of this is coming into the forefront, especially because of the recent cases regarding whistleblowers at the Texas Attorney General's office, and what's been happening there, especially with Attorney General Ken Paxton and the potential abuses of his office that he has allegedly done, and how these whistleblowers not only tried to hold him accountable, but then were pretty much almost immediately potentially retaliated against for their attempts. And it's always important to at least be aware that this is a long process, but at the same time, it's one of the more substantial ways to hold public figures accountable for violations of the law and abuses of the office with which they were entrusted. But yeah, that ends my portion. But next slide.
Yeah, we also just wanted to answer any questions. We know we did receive some questions prior to our webinar starting, and some of the questions that we received pertain to, one, just kind of general advice for anyone trying to utilize their whistleblower rights. And I would say, if you do believe you are you know of any fraudulent activity or any violations of regulations, law occurring in your workplace, to make it aware and exercise your rights by making those reports to the proper officials, and to be mindful of those deadlines that we went over, and those processes you would have to utilize to exercise your rights. I would, make it aware to all the relevant officials, put it in writing, call the appropriate law enforcement authorities, pursuant to the Texas law, whistleblower laws, to help protect yourself. And if there is any retaliation that occurs, utilize the internal procedures that your employer may have, so you could, potentially take it to court thereafter to have those issues remedied. I believe another question we did receive was just about damages again, and specifically, let's see, it was just a general question about damages. And Nathan, if you want to just discuss that, and get to go over the damages that an employee could receive.
Sure. So again, like I mentioned before, there's so long as you're reporting to the right authority, then that in itself can constitute a whistleblower claim. So for example, if we're talking about stuff that's like usually covered by the EEOC, or EEO in this case, so something like sexual harassment, there is also the actionable claims under not just Title VII I believe, but like technically also there's been new updates to the sexual harassment laws at the Texas state level, through which you can bring action as well. But specifically for whistleblower, as I mentioned, there are caps to the compensatory damages. Just to list a few more of those, just so I can better encapsulate what compensatory damages are. So that includes future pecuniary losses, so loss of pay, a loss of, for example, let's say you were denied a promotion, then the difference between what you're earning now versus what you would have been earning had you not been retaliatorily denied a promotion, that would be, I believe, part of the compensatory damages. Also, emotional pain, physical suffering. So you can be compensated for emotional distress. Ways to prove up your emotional distress are, like essentially physical symptoms of your um, of your emotional distress, and as well as anxiety, depression. But for example, loss of appetite, as well as also loss of sleep, restlessness, increased high blood pressure, stuff like that can help prove up that you essentially went through a great deal of pain and suffering, and because of the governmental entity's actions, and therefore you should be compensated for that. There's also inconvenience, which can be covered by compensatory damages, as well as, again, mental anguish, and then loss of enjoyment of life, and other non-pecuniary losses. So non-pecuniary, that just means essentially that the most well-known portion of non-pecuniary is emotional distress, and then future pecuniary losses, essentially things that you would have been given had you not had been subjected to the adverse employment action. But like I said, compensatory damages do have a cap, but things outside of that, I believe, are not subject to that same cap.
And it's important to note that the regulations that protect individuals, employees reporting sexual harassment, sex discrimination, although they may not be specifically covered by Texas whistleblower, for private employees, those laws do protect private employees. So, if you're reporting sexual harassment under Title VII, that does apply to private employees. But for Texas Whistleblower Act and the Texas whistleblower laws, they, like we discussed here, apply to public employees. Let's see, we'll wait to see if we have any other questions.
If anybody has any additional questions, please submit them in the chat and I will send them over to our presenters.
While we're waiting, I'll also note, and this was referenced earlier, there are different but similar laws that apply for federal government employees, which is not a topic here today, but just note that if you're a federal government employee, or if you think a federal government law would apply to you, to speak with the Office of Special Counsel, which is out of the Washington, D.C. area, to utilize your whistleblower rights under the federal government, or could consult with legal counsel regarding that. But just note that there are different laws that apply for federal government employees as well. Okay, well, it doesn't seem like we have any additional questions, but we hope that this presentation was informative. For any legal questions, topics that you had. Again, we do encourage you to seek legal representation for any specific factual scenarios for your intended or ongoing cases. But otherwise, we hope that we were able to provide some assistance here today. We thank you very much for your attendance.